Thank you very much, Professor Schindler. Good afternoon, ladies and gentlemen. My name is Joanna Uchanska. I'm from Poland. It's a great honor of mine to participate in this Global Intellectual Property Convention in India. In the beginning, just a few words about our Polish contribution in the IFSTP project. We have been working on this project since 2011 and making analysis based on Polish cases and European cases because Poland is a member of European Patent Convention. Development of economies, science and societies is strictly connected with creation and implementation of new inventions. The number of inventions which are created in Poland and field for protection is on the rise. In 2012, the number of domestic inventions field for protection increased by over 13% and by 38% patents filed at the EPO. In the end of 2012, over 20,000 patents and rights of protection for utility models and over 22,000 European patents have been enforced in Poland. However, almost 600 new requests were filed under the litigation procedure in 2012. In 2011, 54 patents enforced in Poland, and in 2012, 66 patents enforced in Poland were nullified by the Polish PTO and the EPO. And that's by way of introduction. But coming back to the main point of my presentation. Today, I'm going to present one of the most important and essential topics connected with examination of inventions creativity based on independent and non-equivalent inventive concepts, which are used by 10 IFSTP tests, which help to identify and examine the patentability and patent eligibility of inventions. Firstly, a few facts about inventive concepts. The Supreme Court of Germany and United States have issued judgment in which they seem to seek the method of verification of an inventive step can be more standardized, objective, precise, and clear. The German Federal Court of Justice, in a judgment of 2008, decided that the solution is non-obvious if the inventor makes more than one independent step, starting from the prior art, to find a solution of the problem. Simultaneously, the US Supreme Court recognized the necessity of refining the paradigm of patentability interpretation because of a significant increase of awareness about the complicity in patenting. US highest court ordered to use inventive concept for presenting a claimed invention in a clear way. But the question is, what are inventive concepts in fact, and how to formulate them? Inventive concept is a creative thought represented and embodied in a patent, describing a certain inventive property of a defined element of this invention, of this claimed invention, but in a complete, precise, and clear way. The Supreme Court gave some guidelines how to formulate them, but not an exact step-by-step procedure. However, the IFSTP analysis apply this instruction, and what is more very important, according to the IFSTP analysis, the patent, the warning of inventive concept may be freely chosen by a person who formulates the inventive concept in a natural language. That is why used terms may be different from those used by the disclosures, specification, or claims. They provide also a scientific fundament for precisely modeling patent loss cases, just as for testing a claimed invention requirement in regard to patent law. It means that any question about inventive concept is in fact legal question, which consequently implies a question about the invention. A claimed invention, refined claim construction has 10 aspects to fulfill requirements stated by dedicated patent provisions. These 10 tests greatly support in verifying and examining patentable inventions' inventive concepts. They take claim construction to a much higher level of development than this classical claim construction, because the FSTP analysis is made logically, clearly, precisely, step by step. Each test is strictly dedicated to each real patent requirement. This issue I presented have been partly, I underline, already accepted in US, but not, of course, in Europe. Application of 10 tests shall be analyzed through enforced regulation. In a minute, I will present you a case we have analyzed in Poland with the help of the novelty and non-obviousness test, the nano test. That is why I show you some Polish and European provision. As you perfectly see, the definition of novelty is pretty close to each other, and the definition of non-obviousness is the same. It demonstrates that when I discuss some Polish matters, they are coherent to European ones, and vice versa, of course. Before coming to the case, a few words about an important term, creativity, presented in the light of novelty and non-obviousness, because they are strictly combined with before-mentioned 10 aspects. The creativity is a minimum number of independent thoughts to be invested into creating the innovation when starting from the prior art, considering all PMGP aspects. PMGP aspect means all social or economic consideration. Hence, the nano test shows mainly the creative height of a claimed invention, which indicates, among others, whether a patent may be granted or not. It is as well extremely important to show not only the role of nano test itself, but also the independency of inventive concept and non-equivalency of them. It is very essential to verify that inventive concepts are independent of each other to guarantee not to indicate an excessive semantic height. Secondly, it is essential to prove that there are no equivalent inventive concepts when measuring the creativity. I also want to mention that the nano test it's extremely important for screening a claimed invention for its patent eligibility, as performed by the FSTP test. It has not being not natural law only, non-preemptive, and non-independent. The nano test helps to find out the precise and clear inventive concept of, example, human genome inventions or computer-implemented inventions before statements about these inventions are made without any in-depth analysis based only on political will or common beliefs that some creations are patentable or not. And now, very, very important statement, that checking for a claimed invention, whether it passes being tested for these aspects, is meaningful only after its refined claim construction has passed the test for novelty and non-obviousness of the invention and well-definedness of inventive concept, whereby the tests for its aspect of patent eligibility may impact of an inventive concept. Now, I want to describe an exemplary case. Okay. Something is wrong. I'm so sorry. It's not my fault. Okay, once more, yes. Okay. So, an exemplary case of a FSTP analysis we made in Poland. I will show you how we have chosen elements predicates and concepts, and how we decide and examine them to decide if they are inventive or not. Due to the case we analyzed, it was a method of manufacturing of cheese product. The patent was granted in 2005. Then the Polish PTO invalidated the patent in 2007. After re-examination, once more invalidated in 2009. The holder, of course, appealed twice to the first and second instance of administrative court, and both instances dismissed these appeals. And finally, in 2011, the patent was invalidated. The courts directly referred to non-obviousness subject matter and stated that the only one literal difference between the patent in question and the prior art is the phase of the manufacturing process when after the storage the cheese is mass is left for ripening. According to the court ruling, the difference between the patent description and the prior art publication was esteemed as elusive and the invention was deemed obvious. We based our analysis on a specialist knowledge of diary technology. Nevertheless, after thorough consideration of claims and patent description, we came to the consideration that the description of the invention is very, very ambiguous. During the analysis of the invention, we established that the controversial part of the claim procedure lies in the operation, which describes the method of microbiological sorting as you see at the slide. The controversial element, ripening of cheese, was chosen for the IFSTP analysis, and this element had one attribute, as you see, which in turn had three concepts reflecting the three characteristic features of the ripening phase, as you see also at the slide. After examination, result was as follows. The values of all concepts in the prior art documents were obviously not the same as in the patent application. What is more, on the next level of examining the concept with respect to the prior art documents and the claimed invention indicated slight differences, although the final meaning was the same. The claimed invention has been, in our opinion, anticipated by the prior art document. And in this case, because of that, the creative height was equal to 0. What is more, when we talk about patent eligibility tests, it has to be mentioned that this invention involved at least one law of nature, namely the dependency between time and temperature to achieve a demand pH level of cheese mass. According to the Article 52 of European Patent Conventions, laws of nature as such are not considered to be patentable inventions. However, technical and practical implementation of such laws of nature in a solution may be patentable if all further requirements of this patentability are fulfilled. Hence, in this case, the claimed invention and its practical application doesn't affect the conclusion, but just in this case. The analysis of this case has proven, and it's very, very important, that taking into account the literal wording of the patent claims and the description, even though an invention seems to fulfill the inventiveness criterion, it doesn't mean that this solution is indeed creative. Such a conclusion is only possible after examining patents with very, very precise wording of inventive concepts. And in my point of view, very, very important and essential remark that the judgment which correspond to our procedure have arrived after a long procedure lasting 5 years. However, we achieved it in much shorter period of time, which in my point of view is a great advantage. And to conclude, I do hope that it's pretty clear that occurring during examining invention's patentability is not a problem of provision as such, but a matter of interpretation of patent requirements. The refined notion, inventive concept proposed mainly by the US Supreme Court may help indisputably. From our Polish group perspective, the implementation of FSTP analysis is not only guarantees the fulfillment of rules on patentability and patent eligibility, but also helps to make the examination easily, clearly, precisely, and promptly. We also see that it guarantees some additional profit, like reducing the patent backlog, reducing to zero the risk of improper patent granting, help with communication with the examining division during the patent procedure, improving the innovation to meet patent requirements, and supplying also competitors against the infringing entitled parties' patents. And last but not least, all in all, in our point of view, the only way to achieve higher level of patent quality, which is nowadays on a tremendous low level, it's the application of FSTP analysis. I do hope so that this presentation was as clear as possible, and if you have any questions, please do not hesitate to contact me. And also I try to say that you can ask any question in the coffee break space, and also we can show you some further information. Thank you very, very much for this, for your attention and for the invitation for this conference. Thank you.